This is the case of a polite bank robber, one that asks please, says thank you when he gets the money, and even allows a bank teller to call the police while he's making the robbery.
Excuse me, I'd like to open up an account.
Well, great. What type of account do you have in mind?
This kind. This kind.
In the 11th Circuit case, United States versus Perez, Mr. Perez robs two banks within a span of 1 week. And essentially the facts are the same. He comes in, hands a note to the bank teller, which essentially says, please give me the money, at least $5,000. I have kids to feed. Please call the police as soon as I get out of the bank. Mr. Perez gets charged with robbing two banks under 18 U.S.C. 2113A. Now, he accepts responsibility, meaning he pleads guilty, and before he can be sentenced, a probation officer prepares pre-sentence report. Now, in this report, usually the probation officers get information about the facts of the case, about the criminal history, the individual's personal history, medical history, employment, and so on. Now, this particular officer recommends a 2-level increase or enhancement under the guidelines because Mr. Perez made threats of death. Now, because of that, the guideline offense level comes up to level 23. Under criminal history category 1, because probably Mr. Perez had no criminal history, the guideline range becomes 47 to 57 months in custody. Quick side note, I have several videos that discuss the guidelines. I have one video that discusses how to calculate criminal history category, and I will link it here above. I also have several videos that discuss how to calculate offense levels of certain federal offenses that are more common in our district, the Southern District of California. But in this case, Mr. Perez is looking at the range of 46 to 57 months because of that 2-level enhancement. Of course, during sentencing, he objects to the 2-level enhancement and says that it should not be applied. The court rules that it does apply and sentences him to the low end of the guidelines, 46 months in custody, which brings us to this case, his appellate case, where he argues that the court made a mistake of enhancing his guidelines by those 2 levels. Under 18 U.S.C. 2113A, a defendant will be found guilty of a bank robbery if he takes or attempts to take money from a bank by force or violence or by intimidation. Now, after the defendant pleads guilty, or if he is found guilty at trial, the guidelines will apply. And the guidelines try to sort of balance those robberies that are bad and the ones that are even worse. Now, one of the enhancements under the guidelines is that a 2-level enhancement applies if there is a threat of death. Now, this threat can be expressed or implied. The question is, did a reasonable person who's a victim in the case feel like their life was at jeopardy? Because we're talking about a reasonable victim, the court engages in a discussion of other cases from other circuits that had similar facts. So there's one case where the robber told the teller that you have 10 seconds to give me the money or I'll shoot. There's another case where the bank robber told the teller simply that if you don't give me the money, I'll shoot. And in both notes, both of those defendants had a reference to the fact that they have a deadly weapon in their possession. Now, of course, a reasonable person looking at that type of note would assume that if they get shot, they can die, and they would fear for their life. Now, the appellate court says that an enhancement should have never applied. They look at the facts of the case and say that Mr. Perez gave a note that didn't suggest that there was any weapon involved. He was also wearing plain clothes. He wasn't wearing a mask. In the second robbery, he was wearing shorts. And the way the tellers reacted to him was also showing us that there was really no threat of death. In the second robbery, the bank teller did not want to give the money, and they sort of had a conversation back and forth about how much money he was willing to give Mr. Perez. Because of those facts and because of how polite Mr. Perez was, the court said that the enhancement should have never applied. Now, the court also noted that if we start treating all threats as threats of death, then the application of the enhancement would sort of overpower the rule, meaning that it would always apply in all bank robberies. So the court says that we should be careful about reading the facts and figuring out when it applies and when it doesn't. If you enjoyed this video, please click like, subscribe, hit that bell notification button so you know when I post the next video.